This is Jack Campbell. He's the owner of Lone Star, and Brandon Pinson. He's the lawyer over there, and I think he's a little bit owner, right?
No, not yet.
Okay.
I'm what?
Owner.
No, that's the owner.
So we'll let them take off and give the presentation.
How are you guys? As he said, my name is Jack Campbell. I'm the owner of Lone Star Abstract and Title here in Midland. We have a plant in both Midland and in Martin counties. And they asked me to come and talk to you guys a little bit about the title company and what it is that you do. Okay, and I know that many of you do a little bit different. So what I thought I would do first is talk about the way the title company sees a lot of the different people, a lot of different ways that you guys can make money. So a couple of definitions first. This may not be how you see it. This is what we kind of see. We call a wholesaler agrees to purchase a piece of real estate for a certain price, then agrees to sell the property to another party at a higher price. Difference in price paid for by the buyer is the profit retained by the wholesaler. A short sale in real estate refers to a sale that takes place when a financially distressed homeowner sells the property for less than the amount due on the mortgage. And so you've got to negotiate with the lender to be able to do a short sale. A flipper refers to somebody who buys and sells homes or properties for quick profits, often after refurbishing them. Title insurance insures you against loss resulting from certain risks to your title. And a title commitment is the title company's promise to issue a title insurance policy. So that's what we issue as soon as you guys bring us a contract or something like that. We issue a title commitment that explains who we find in title, what are going to be the requirements for us to be able to close, and what are the exceptions to the insurance itself. Oh, no, exceptions. Exceptions are the risks that the policy does not cover. So a title insurance policy is a little backwards. As opposed to saying, here are all the things that we insure you of, a title insurance policy says we insure you of everything but. Okay, so the Schedule B on a title insurance policy or a commitment are the buts, okay, the exceptions. Requirements are the items that have to be satisfied for us to be able to issue the policy. Okay, the good. There's nothing illegal about the practices that you guys are doing. I know you feel like the title companies are beating you up about different things, that they think you're shady or something like that, and that's not the truth. What you guys are doing is legal, as long as you don't intend to defraud, okay? And that's sometimes where we get at odds a little bit. Most of the time we can close with no big issues. Title insurance companies can be reluctant to insure, so a lot of people in your industry are willing to take certain risks. The title companies, more so than the title companies are, okay? And that's a lot of times where an investor and a title company get at odds, okay? Is the title company says, well, we've got to clean this up, and we've got to do this, or we've got to disclose this, and the investor's saying, no, that's not the way I do things. So we're going to talk a little bit more about that. Probably one of the biggest things, particularly with wholesalers, for us, I can't speak for every title company, although I'm from talking to other title companies here in Midland and Odessa, both, they feel much like I do. If you are going to flip a piece of property on the same day, in other words, you're going to purchase it and you're going to sell it on the same day, there are two things that we require that are contrary to what some wholesalers want. And the first is you've got to actually buy the property. Okay, you have to put up the money to buy the property. You can't use the sale proceeds to be able to buy the property. Okay, and the second is that we require a disclosure. So what happens in many cases with title insurance companies are involved in wholesaler transactions is they come in, they buy the property for $60,000 and they turn around, 2 hours later and they sell it for $120,000. Then eventually the buyer finds out that they only bought it for $60,000, and then they file suit against somebody saying, hey, you didn't tell me that that's what you were going to do. That's fraud. And then of course you've got a jury to decide that. Okay, there's no clear law as to yes or no, is it fraud, is it not? You're going to have a jury involved in finding all that out. A title company wants to avoid all that. So they're going to require some type of disclosure that the seller, the wholesaler, and the buyer all sign saying, hey, here's what's going on. And that may be contrary to what you want. Okay?
What if it's a title assignment or like a contract assignment?
Well, you can, I don't know everything there is to know about other ways you guys can make your fees. I have had wholesalers come in and charge, and the sale was strictly from the seller to the buyer, and the wholesaler charged some type of fee, basically their profit in the transaction. That's fine. Okay, as long as the government or Fannie Mae doesn't have a problem with how it's disclosed, or a lender, then we're okay with that because it's disclosed to everybody. Okay, good question. Quitclaim deeds. I know that many investors like to use quitclaim deeds. We will not insure on a quitclaim deed. A quitclaim deed, just a little education on deeds if you didn't already know, a quitclaim deed is actually not a deed. Okay, it just basically says, hey, I have no clue what I own, but if I own something, I'm giving it to you. Okay? The next step up is a deed without warranties. Okay, and a deed without warranties has the legal language that it conveys the property to the buyers. There's some intent to convey the property to the buyer. It doesn't have a warranty involved, but there's that conveyance language that's real necessary. We won't insure on that either. A special warranty deed says, same thing, I'm conveying the property and I am warranting the title while I own it. Okay, yeah.
Repeat the second one again.
A deed without warranties. Okay. A lot of times you'll see that in maybe a divorce or a probate maybe. Other ancillary things. But if we're going to insure a deed, it's got to be a special warranty deed or a general warranty deed. And the special, as I said, only warrants the title while they own the property. A general warranty deed says the seller is warranting the entire time that the property has existed. Okay? And that's why title insurance is important. If you're giving a general warranty deed, the title insurance is backing you up. Okay? It's some insurance for you, even though it's actually insurance for the buyer, it's insurance for you too, because you're given that warranty. Okay? We will insure on special warranty deeds and general warranty deeds, but not the first two. Okay? We have found some, and not in Midland, but in the state we have seen flip transactions or wholesale transactions where there's an appraiser that's kind of in the game and throws up different kinds of appraisals that aren't necessarily true in order to make the deal work. And obviously we want to avoid that. And that's what I just said. If the original seller finds out that you sold it for half of what twice what you bought it for, a lot of times you're going to have a lawsuit involved. And again, it doesn't mean that you've done anything illegal or that you have committed fraud, but you're going to pay an attorney and court fees to prove that. And the title company not only wants to prevail in making sure that what they're doing is correct, they also don't want to go to the courthouse. Okay? A wrap. A seller has a loan on a piece of property, and instead of paying the loan off, seller agrees to loan the money to the buyer. Buyer makes payments to the seller and the seller makes regular payments to the lender, or the buyer makes payments directly to the existing lender. We will only insure a wrap as long as the lender knows what's going on. Okay? And the reason is almost every single loan out there, and I can promise you every mortgage loan out there, because I know that Fannie Mae requires it, has a due on sale clause. Okay? And what that means, let's say that the seller buys the property, wraps the note. Well, the buyer's original loan may have a due on sale, probably has a due on sale clause, meaning if they sell the property, the loan is immediately due and payable. Okay? So even though you intended to go ahead and make the payments and everything's fine, you don't want to trigger that due on sale clause and the lender's calling you up and saying, hey, you know, we want the entire balance of our loan right now. And of course, the title company doesn't want to be involved in having to pay off that loan right now either.
How often do you see that happen?
Um,
Or have you done any reps?
I have done wraps in the past. I don't see it very often because I tell them that they've got to disclose that to the lender, and a lot of the people involved in reps don't want that, and so they try to find somewhere else to go.
The ones that you have done, I mean, if you disclose to the lender, does it trigger the due on sale, or do you just need?
No, we get something from the lender saying that, you know, as long as the payments are made timely, that they're not going to trigger the due on sale clause. And that gives us a warm fuzzy to be able to go ahead and make the transaction work. What happens if the seller doesn't make the payments? The buyer can be, you know, if the buyer's paying the seller and the seller's paying the mortgage, if you, the buyer, buys the property and that seller is not making their payments, all of a sudden you could lose your property, okay? Because that lien was on there before your deed. As I just said, we can insure a wrap, but there has to be a notice from all parties, including the lender. If you are lending money, I know a lot of investors have done this. Unfortunately, the Dodd-Frank Act killed a lot of that. So the Dodd-Frank Act basically states that a seller financier has to be a licensed mortgage originator unless they qualify for one of the two exceptions, a 1 property exception and a 3 property exception. The 1 property exception is a natural person, estate, or trust providing seller financing for only 1 property in a 12-month period. And 3 property exception is any type of seller financing entity finances a sale of 3 or fewer properties in any 12-month period. So the bottom line is, unless you are a, what was the term, loan originator, a licensed loan originator, you can't loan money for somebody to buy their house on more than 3 transactions at most in a 12-month period. And I know a lot of people used to make a lot of money doing that, doing seller finance transactions. You know, they may even fix up the home and sell it, and they want to do a seller finance transaction. But if you're doing a bunch of that, you're going to run into problems here.
Does the 1 and the 3, does that not contradict each other?
Well, no, because the first one has more to do with, the 3-1 has to do with seller financing. And the 1 has more to do with financing your daughter, or, you know, you weren't the owner of the property. Okay?
You're actually lending the money, not financing the property.
Say again?
You're actually lending the money, not financing the property.
Exactly. You've probably all seen a seller finance transaction. It's even on the contracts, you know, where the seller can loan the money to the buyer because they couldn't get a loan, they trust them, and they do a seller finance transaction. We can do those, okay? We used to do a ton of them, but not anymore because of this.
Would that be per LLC?
That's a great question. Probably, because an LLC is its own entity. So I would think that that would comply with the rule. I'd have to ask. But
I'm not going to do it, I was just...
yeah, let me first of all say I'm not an attorney. That's the attorney over there, okay? But I don't see where that would be an issue. One thing that I really wanted to impress upon everybody here is the value of incorporating. And I know that the margin of profit for you guys is small. And you don't want to do a whole lot of paying attorneys for this or paying attorneys for that or whatever the case may be. Trust me, you will be much happier in the long run if you put your company into an organization, a limited liability partnership, a limited liability company, something like that. Those are things that Brandon can help you with. I don't think he charges a ton of money to be able to do that. And it protects you, and it also eliminates the joinder of spouse requirements that title companies make. Okay? If you are an individual, and even just a DBA, and you own a piece of property, it's your business property, and you sell it, almost every title company in town is going to require your spouse to sign on the deed. Okay? And the reason is that spouse could claim that property as homestead, and in the state of Texas, homestead is king. If you do a corporation or some other type of entity, then you can avoid all that. Okay? And Brandon could probably go on for days telling you how, you know, that protects you as well. I know there's some initial costs, but once you get incorporated, you're not talking about a ton of cost afterwards. So I impress upon y'all to do that. Why title insurance? Again, a title policy is your safety blanket that the home you're buying is protected from covered title problems. It's a one-time fee and it's good forever. Okay, so again, if you gave a warranty deed, then, and it sells 3 years from now and sells again 10 years from now, and they find a title defect in 15 years, well, you've got that warranty deed out there saying, you know, that you warranted the title, and somebody can come back against you. Again, that title insurance is kind of your safety blanket. Protects from divorce claims, probate claims, liens, missing grantors, easements, access, adverse possession, forgery, fraud, and many more. So that's kind of the relationship between, you know, us. I wanted to make the presentation fairly short because I wanted to leave it up to questions because I know you guys have some questions and I'm going to attempt to answer them. The main thing to understand is that even when you're willing to take certain risks, the title company may not be. Okay? And I don't know a lot of title companies that are willing to go into a lot of risk for a client throughout the state of Texas, not just in the Midland, Odessa area. And that's where a lot of times the rub comes between investors and title companies, because the title companies want all these things done and the investor doesn't, you know, again, that profit margin is small, and you don't want to use up your profit margin doing a whole bunch of cleanup and fixes and legal matters and all that sort of thing. So, questions about anything? Yeah, Lee.
When I sell a property, I don't like in the paperwork of the sales thing having that I take responsibility, I forget how it's worded, forever. I just say that I do it for mine. Can I still get a warranty deed, regular general, even though I personally am not saying that, because, you know, I know what happened to the property while I owned it, but before I owned it, back to the way the Indians.
So a special warranty deed only insures the property while you owned it. Okay? And a title company is most of the time willing to insure on a special warranty deed. Okay? So in your case, you don't want to go off on that limb where you're given a general warranty deed, because if you give a general warranty deed, you are warranting the title from the beginning to the day you sold it.
Are we doing it or the insurance company doing it?
Well, you're doing it by doing a general warranty deed. Okay? I mean, the title company may be, the attorney who's preparing the deed may be preparing a general warranty deed, which is what we prepare 99% of the time. But, you know, for special, in special instances, we accept special warranty deeds. Most all of our title insurance underwriters don't have a problem with a special warranty deed. But remember, if you are giving a general warranty deed, if there is title insurance, then you've got that to back you up. Okay? Does that help answer your question? Okay. So there is a way of doing what you want to do.
But that means that most lenders are gonna want a general, right?
Okay, and that's a great point. If, let's just take a remodeler, for example. You buy a piece of property, you spend a couple of months fixing it up, you're ready to sell it, and the lender says, no, I require a general warranty deed. And I require the seller to sign it. The lender can come up with requirements that don't have anything to do with the title company. And, you know, not much I can do about that other than try to talk with all the parties and make some type of arrangement that's going to work for everybody. But that's a great point. The lenders oftentimes are going to require certain things certain ways. I've been asked by investors before, let's say there's a particular risk. And the investor says, and the investor's buying the piece of property. And the investor says, I'm willing to take that risk. We can make an exception on our policy as to that risk. And therefore, we're not insuring the problem if you're willing to take that risk. Okay? However, you get to the point where you want to sell the property, and then at that point, that same requirement is going to come up to solve that issue. And we're not going to be able to just make an exception to it because I can guarantee the lender won't allow it on their policy. Okay? And most buyers won't allow it on their policy. But it's really the lender gets the hang up. So I know that comes up for you guys as well. Other questions? Yes, ma'am.
On average, how long does a title search take?
We get all of our stuff out in 10 business days. If you need it before that, we can usually work a miracle here and there. It's crazy busy right now, but we're still getting things out in 10 business days. I have
Mr. Campbell to come. We had talked probably 5 or 6 months ago, and he said that, you know, if he needs to, and we need a rush on getting this work done, because there are times when it really will make the deal go through. If you can do it short, that he will make it happen.
I've had investors come to me and say, the lady is on her deathbed, okay? She's going to die any day now. I need to close tomorrow. And, you know, we can go as fast as we can. I don't know if we can do it tomorrow. But we will make every effort to get it out as fast as we can. My plant manager is pretty good about helping, as long as everybody doesn't want to rush, because if everybody wants a rush, there is no rush. As long as everybody doesn't want it, we don't get into a big problem with that. So. Yes, ma'am.
I hold a property in my own name,
Mm-hmm.
and I wanted to move it to a trust.
Okay.
I was gonna quitclaim deed it, but now with what you said, I'm not sure I should do that.
Yeah.
What would you suggest as far
Brandon,
as?
you want to take that one?
So,
Do you have a loan?
No,
Okay.
how long have you had the property?
since 2007.
Okay. So, I mean, as long as you've had the property, I mean, we can do a, title search. I can do a title opinion for you and determine if I think there's any problems with the prior ownership. But probably you could just do a general warranty deed from you individually to the trust or to an LLC.
Okay. And the other property's in an LLC, and I was trying to do a little asset protection.
Mhm.
Do I just will the shares in the LLC to somebody instead of moving the property out of the LLC into a trust?
Yeah, so if the LLC owns the property, then you own an interest in the LLC. It's either a percentage or units, and then you can just give those in a will, and you can specifically say, these units of this LLC.
Right, okay. The other one, I'll look into the warranty deed?
Mhm.
Okay.
Another thing that's a real good, hang on just a second. Another thing that's a real good thing to point out. Brandon does a lot of attorney work outside of the title company. Okay, you may come to him and say, I have investigated this property myself. I feel good about it. I just need a deed. Okay, and Brandon can prepare a deed. At this point in the game, Brandon has decided, and I think most of the title company attorneys in town, that he still wants to run the title himself and take a look and make sure. Because we've just had too many people come back and there was a problem, and they said, well, the title company attorney did it. And so, they're not only are they trying to say the attorney did something wrong, but now they're trying to pull the title company into the problem as well. And so Brandon's made a decision. He wants to make sure he knows that what his deed is doing it correctly. Okay. He doesn't have a problem doing a deed without title insurance for you. Okay. But he's probably going to do a little investigating himself and make sure it's going to work okay.
So I'm going to do a kind of a cursory search. I'm going to go back to the prior vesting deed and make sure that I'm comfortable with who's coming in. But if I do the deed through my law practice without title insurance, you're going to give me a disclaimer saying, you've given me the title work, and I'm to a certain extent relying on you because I haven't done a title opinion back to the ARC.
Right.
Other questions or nightmares that you've had with the title company, or things that hold you up, or any of that sort of thing?
On subject to,
Now, when you say subject to, you mean a wrap mortgage?
yeah, basically, so as long as you disclose and everybody's good with it, we'll close it. My question is, give me a second.
That's
Come
okay.
back to me.
That's all right. Anybody else?
I've heard some title companies had trouble with trust. What should we look out for or not do instead of me taking title to it, have it go straight to the trust?
So if we're insuring a transaction either into a trust or out of a trust, we need to see the trust documents to make sure that we feel like that what you're doing is allowed by the trust. And so now there is a provision in the estates code and the property code where one of the reasons you have a trust is to be more private. So everybody doesn't want all their business known, and so there is a way that either your attorney can provide certain general information to us. It's called a certification of trust or certificate of trust, and they can provide that information to us. That's down to the to the nitty gritty on what the statute requires, and we'll accept that. A lot of times when people are doing a transaction, I'll actually look at the trust agreement and I'll prepare the certification of trust so that information isn't more public when things are filed. There's kind of Jack and I have talked about this. Some of the underwriters now are really wanting those certifications of trust filed of record. We've sort of taken the approach at this point that we're not going to do that, but that may be coming. But the certification of trust is a very streamlined bullet points of the trust and who the trustees are and what powers they have and that kind of thing.
Do you actually create the trust yourself?
Yes.
And what is the general charge?
You know, if you're doing an estate planning trust, for instance, as opposed to a will, I mean, I tell people, generally, I mean, probably $2,500 is going to be a starting point on a trust. In Texas, you can either do, you can have all your assets in a trust and administer it that way, or you can have a will. And I tell people in a general rule, you're going to spend about the same amount of money. The trust is all front-loaded because you pay for the creation of the trust, and then everything has to be in the trust, everything. Because if you don't get everything in the trust, then you have to probate a will to get everything in the trust. And so if you just do a will is usually easier to change as a general rule as you move along in your life and things change. The trust can be changed as well. But
Lee, if you're thinking about doing a trust for business purposes, again, I would highly recommend the LLC as opposed to a trust. I think you're much better protected in the LLC than you are in the trust.
And I don't know how many of you buy and hold properties, for instance, but I've had clients in the past that owned 30 or 40 rental properties, and we would actually put 4 or 5 properties in a LLC and kind of split them up. Because your liability, if you get sued, or I always talk about the gas explosion at the rental property, your only exposure is to the assets that are owned by that LLC, not your entire 40 property, catalog of properties.
So you end up kind of protecting yourself that way. What else?
Not to go too far.
No.
The thing is, since he brought it up, I heard a person tell me that they like to put everything, another attorney, put everything in the trust except for one property or so. So it actually went through probate because from what he was saying, that once you give the notifications to the paper, however they do it in Texas, that once it goes through probate and the trust that's closed out, then all lawsuits have to stop as far as any creditor comes. Like if I had died or something, once that period's gone and the probate's finished, then everything stops. Whereas if it's all in a trust, then it never really closed anything, and people 5-10 years from now could come up and say, oh, you owe me money.
I don't know the exact, I'd like to have more of a conversation maybe with that attorney. I don't know, but generally your claims on an estate are run with the regular statute of limitations. So, if somebody takes out a loan the day before their death, generally on a contract, for instance, they're going to have 4 years to enforce that. And the estates code, you can give certain notices to cut that down, but I don't know if I necessarily agree with that.
Okay. Well, that's why.
Okay, coming back to me. As far as writing up the wraparound, along with the contract, I mean, do you need something else? I mean, could y'all prepare that for me?
Yeah, we can, what we do, a lot of times on a wrap, what they'll do is a wrap note and deed of trust, okay? And that protects the seller and the buyer in the transaction, kind of spelling out how all that's going to work. And like in an assumption, you get an assumption deed of trust, again, to protect the parties. So it's similar to that. It's not required that you do that, but that can be done. Does that help answer your question?
Yeah, my question was more like in the front end, like actually writing that contract. So would I just get something from y'all, or besides like that, the closing?
How to write the contract?
Yeah, exactly.
Well, that's a great question.
How would it make it easier for me to see it and to understand what's going on?
I don't know of any other provision in the tract contract, so I guess in special provisions, you'd put that the purchaser is going to accept the property by wrapping the existing mortgage or whatever. Right. Yeah.
So with a wrap, the mortgage lender is, 'cause I'm a mortgage lender.
Yeah, sure.
So with a wrap, the lender is actually the first lien holder from the seller. And then whoever's buying it is just like seller financing back to them.
Exactly. And a lot of times, in a wrap situation, you may be selling the property for more than the actual outstanding balance of the note.
Right, yeah.
And so you want to include that in your wrap deed of trust too.
And can the seller collect an interest above and beyond what the?
Yeah, they can collect an interest.
As long
I
as
don't
the
know
lender's
if
gonna pay.
it triggers Dodd-Frank or not. I don't know, I'd have to ask somebody that question. But yeah, I mean, in effect, you know, the seller would be loaning the buyer X number, if the buyer wasn't gonna just actually pay that portion out.
But, yeah, that wrap deed of trust is gonna reference the original the original loan and the deed of trust.
Okay.
So,
And then the subject to, or the wrap is like a second lien.
Exactly.
Okay.
If all there was the original loan, then it wouldn't do Dodd-Frank's, right?
Well, what he was asking is if you do the wrap and we do a wrap deed of trust, because the sales price was $120,000, but the existing balance of the loan was $100,000, and the seller was going to be, in essence, lending $20,000 to the buyer. Does that trigger Dodd-Frank? And I don't know the answer.
I suspect that it does.
Okay.
If it meets one of these requirements.
It's still seller financing.
It is.
I think
That's right.
But if it was just the $120,000 on the loan and it's selling for $120,000, then it would not.
Then you're not loaning money.
Right.
Correct. Yep.
What if the seller has an equity position still, besides what's on their mortgage? Would that be just written into the contract as well, that's being paid to them, besides what, taking over the loan?
Say that for me one more time.
The seller has an equity position, so
When you say equity position,
like
you
they
mean?
got equity in the house.
They got equity in the
Yeah,
house,
so
okay.
they owe $60,000, the house is worth $150,000.
Okay,
But they're willing to sell it for, I don't know, $100,000, so
okay.
if you're giving them those $40,000 up front, and then taking over that loan, would that be written into the contract as well, or would that kind of be like a side deal?
Now, I would think that you would write that into the contract as well. More, I tell realtors all the time, the more you put in that contract, the better, because you don't want to take undue risk as a real estate agent. But that contract is a map for the transaction. And nobody wants to get all the way to closing and somebody say, oh, well, what about the propane tank outside? And that wasn't ever disclosed, and so we're scrambling at the last second to take care of those things. So yeah, the more you can, and if you're not comfortable putting in the contract, if you just want to tell us, that's fine. But I like things in the contract because everybody agrees to it. Both agents, both buyer and seller. What else, guys? And ladies, sorry.
What are your insurance rates?
So title insurance in the state of Texas is promulgated. And that means it doesn't matter what title company you use in the entire state of Texas, the title insurance rates are the same. Okay? So you're not going to get title insurance any cheaper at any place in town because they all are required to charge the same price. Now, we all charge different escrow fees and other extraneous fees. What we do at Lone Star is we try not to nickel and dime you with this fee and that fee and this fee and that fee and all. We charge, a larger escrow fee, and then you don't have a lot of that. As a seller, you're going to pay for the preparation of the deed. You're going to pay for any outstanding liens. You're going to pay for any realtor commissions if there are any, recording of any releases, of anything that has to be released, and that escrow fee and the title insurance. And that's another thing. If anybody's ever told you sellers have to pay for the title insurance, that's not true. Okay? That is completely negotiable. Okay? You can negotiate with the buyer to have the buyer pay all the title insurance. You can negotiate with the buyer to half and half it. Just whatever you guys come to an agreement with, we can do it that way. It is very typical for sellers to pay for the owner's title policy and buyers to pay for the lender's title policy. But a great example is every builder in Midland, Texas does not pay for the title policy. Okay, most of them require the buyer to pay for their own policy. Okay, so that is negotiable.
As an aside to that, the title company is negotiable as well.
Yeah.
So you don't necessarily have to, I think the kind of the prevailing standard norm is that the buyer,
I've heard it.
You can pick
I've
your,
heard
pick your
people
side.
say it's the listing agent's decision. I've heard people say it's the buying agent decision. I've heard the rationale behind. It's negotiable.
Yes, negotiable.
Okay, it's usually whichever real estate agent's more hard-headed about it is the one who wins. So. Now, builders, they've got relationship with certain title company, and doesn't matter what the realtor says, they're closing at a certain title company. Investors can be that way too. Okay, so it's just whatever you guys agree to. I know y'all have had more horror stories than that.
Can you dispute a lien?
Can you what?
Dispute a lien?
Explain to me by.
I just heard someone mention a lien,
Mhm.
so I was just wondering if you, I don't have a specific.
So you mean an existing lien? So a payoff of a lien is negotiable. Okay? Now, if the owner of that loan is Wells Fargo, you're probably not going to get real far in negotiating. Okay? If the owner of that loan is Community National Bank, you might. Okay? If the holder of the note is an individual, you probably have more negotiating power. On on other liens like judgment liens, abstracts of judgment, a lot of times those are negotiable, and that's why we don't go and order a payoff of a judgment lien. Okay? You don't want me calling the person that you lost to in a lawsuit and saying, "Oh, Billy Joe's selling his property for $200,000. How much do we owe you?" Okay? You want to be able to go to that person and say, "Okay," and negotiate it yourself. Okay? Almost all of you are very good at negotiating. That's why you do what you do. Okay? Trust me, you're better at negotiating than I am. Okay? So we usually put that back in your court and let you negotiate. As long as we've got it in writing that you and that lender are in agreement with how that's going to be handled, we're fine with it.
We've had people fight like city liens on because
Yep.
they didn't cut their weeds or whatever, but we don't typically get involved with that. We're just trying to close the deal. But
But yes, you can, you can take all the time you want before closing to negotiate those things and try to get those things solved on your own terms, as opposed to us requiring it to be done a certain way. It just has to be done.
As long as it's done before closing.
That's right. When it closes and it funds, the magical, it is now your property, is when that transaction funds. Okay? And the seller gets their money. If you ever wondered what a vendor's lien deed is, in a deed is, a vendor's lien is where the seller in the transaction reserves a lien against the property until they get their money. Okay? And so that's why title companies, that's why you close at a title company, is because that title company wants to make sure that seller gets their money. Okay, because otherwise the deed can be worthless. Or not valid, I should say. What else? Listen, guys, if you have questions, if there's some way that we can help you, we would love to try. Please feel free to give me a call at the title company or Brandon, either one of us. We'll be happy to talk to you, answer your questions, and hopefully we can work with all of you more often. So,
Can I say one more thing?
yeah.
So one of my favorite things about Lone Star, so I was in private practice for a long time before I joined Lone Star. And one of my favorite parts about Lone Star, and I learned this a number of years ago, is that we have 6 underwriters, or 6+. And so every week we have a rotating basis of who we use as an underwriter. But sometimes an underwriter doesn't give us the answer that we want for whatever reason. There are some things in the law that are very black and white. There are some things that are gray.
90% of it's gray.
Yeah. Some underwriters, just like y'all, and so all of us we're willing to take more risk than others. And so what's unique about Lone Star as other title companies in town, some of the title companies in town they're owned by underwriters, and so they can't go and shop to other underwriters to get an answer that they want. And so a weekly basis we
Shop around for
we
the best
shop
answer.
around. We email, sometimes we'll email 3 underwriters at the same time with the same information, and we get different answers.
3 different answers.
Yeah.
And that's valuable to you because a lot of times you're buying distressed properties and things like that, and there may be, the seller's got a lien against the property, and that's been holding them up from being able to sell it, and they're willing to sell it at a really great price for you that make you some money. We can shop those deals to different underwriters to be able to get an answer that we like better.
And we've developed personal relationship with some of the underwriting attorneys, and so we kind of know what their risk tolerance is, and we know, like sometimes I can just tell you that if we get one answer from a title company, you're not going to get another different answer. That's just the way it's going to be. But I also know that there's other certain underwriters at certain companies might be willing to insure what you're wanting. So just keep that in mind. It's unique to Lone Star.
Agreed. All right. Well, I appreciate your time, guys. Like I said, please feel free to call us or email us or whatever. My email is jack@lonestarabstract.com, and his is Brandon at lonestarabstract.com. Or you can give us a call, and we'll be happy to work with you. Thanks.
Thank you.